Good morning and welcome to our September edition of peopleHUB. Delighted to see everyone in the room today. This event is proudly sponsored by 1HR. If you've not met me before, my name is Victoria Brown and I am the chair of our series of peopleHUB events. I'm delighted today to be joined by Kendal Hulme. Kendal is the head of operations at a HR consultancy called HPC. She is, I'd like to say, a bit of an employment law expert. She has been looking at the changes that are coming through, or proposed changes, I should say, from the Labour government. So like we always know, if there's a new government administration, there is always lots of changes in employment law. We all, if you are a business owner, HR consultant today joining us, we read the manifestos for the various parties, and we know there will be changes. What they will be, we're not 100% sure yet, but Kendal's going to talk us through those proposed changes. And it's a great opportunity as a business owner or a consultant here today, or a HR professional, to think about what you could be doing now and consider your clients, and maybe some that will be more exposed than others to these changes. She's also, Kendal, going to just recap on a few changes that have been made in the year. She did do a session earlier on for us as well in the year, which was fantastic. So we are going to record the session as well today. So if you've got colleagues that you think would benefit from this, please do. We will share this with you, and please do share this after the session. But before I hand over to Kendal, I just wanted to remind you of the way in which you can ask questions today. So by all means, you can pop something on the chat, but we do use Slido. So if you can see on your screen now, you've got the QR code. If you just want to click on that, I'm going to actually do it with you. Click on it. Again, if you're using your phone to watch today, don't worry about it. You can pop something on the chat. If we've got time at the end, please just, if something comes into your head, pop a question in there. I will try and ask Kendal at the end any questions. If we do run out of time, we always do follow up with the questions and the answer session after this. But I'm going to stop talking now because Kendal's got a huge amount to get through today. So Kendal, thank you so much for joining us today, and over to you.
Thanks, Vic. Yeah, we do have a lot to talk about today, and I feel like it's going to be an awful lot to take in. So as Vic said, the recording's going to get shared. So you may need to rewatch this 2 or 3 times to actually retain all of the information that we discussed today. 2024 has just kept everybody beyond busy so far, and we're only 3/4 of the way through it. It's felt like legislation changes and updates are just absolutely endless. So today what we're going to cover is an overview of some of the confirmed, expected and potential changes to the HR practices and employment law that we can expect to see from a Labour government, and the imminent publication of the Employment Rights Bill on the 12th of October. And that date I'm probably going to say about another 100 times throughout this, because the majority of these changes are going to be discussed in more detail when we get our hands on the text of the Employment Rights Bill on that date. So I have, if you just change the slide for me, Dan, I have popped some of the timescales of these changes as well where possible, and of course how best to prepare for them without knowing the full details of them all. So if we just move on to slide 6, the actual Employment Rights Bill itself. So this is part of Labour's commitment to bring forward the bill within the first 100 days of their government. The bill is expected to be introduced by the 12th of October. First time I've said it, not the last. And once introduced, the bill will go through the parliamentary process, which can take several months depending on the complexity of the legislation and the level of the debate and scrutiny it's going to receive. Some of the expected changes are outlined on this slide, and we will go through them in more detail on the following slides. After the bill passes through Parliament and receives royal assent, the specific measures within the bill will be implemented according to a detailed timeline set by the government. This timeline can vary, but typically some provisions might come into effect immediately, whilst others could be phased in over a month, over years, to allow businesses and workers to adapt. They're not going to be the majority overnight changes. So the government is likely to provide detailed guidance and timelines for each specific change once the bill is closer to becoming law. We won't know the final contents, of course, until we actually see the text. But as part of our service at HBC, what we do is we keep our clients up to date with all of the changes in real time. So as soon as we know, we prep our clients and help guide them through all of the changes. So if we start with 0-hour contracts, there's quite a big one. The Employment Rights Bill has proposed significant changes to 0-hour contracts compared to how they're currently handled. There's over 1 million workers at the moment in the UK that have got 0-hour contracts, and Labour's intention is to tackle the abuse of these types of contracts. So currently they offer a lot of flexibility. They allow employers to hire staff with no guaranteed hours, providing flexibility to both the employers, the employees. But there is insecurity with this. Workers often face financial instability due to the unpredictable hours and income. There are also fewer employment rights for those that are on the workers that are on 0-hour contracts compared to those that are on the fixed contracts. So the changes that Labour are proposing is banning these contracts that they refer to as exploitative. The aim of that being ensuring workers have more predictable and secure employment. They want to guarantee hours, so workers will have the right to a contract that reflects the number of hours that they regularly work. And employers will be required to give reasonable notice for shifts and provide compensation if shifts are changed or cancelled. So that was very difficult to different to how this works currently in businesses. So hospitality, for example, it's a major change that could potentially come into place and a huge impact on them. So with that, you're looking at potential costs increasing as well. So businesses could face higher costs due to the need to provide these guaranteed hours. And obviously the compensation for shift changes and shift cancellations, this is going to affect a lot of people and a lot of businesses quite dramatically. On the positive side, you do have businesses that might benefit here from a more stable and motivated workforce, which could potentially lead to higher productivity, lower turnover rates. And the new government have suggested that these changes are aiming to balance the need for flexibility, businesses and for employees, with the rights and security of the workers. So the timescale we're looking at, again, we'll know more on this on the 12th of October. It's not 100% clear yet how this is going to work. It may be that they provide workers who want the guaranteed minimum number of hours each week with the opportunity to move to a permanent contract that reflects their regular hours. They may also possibly let those who prefer flexibility with a 0-hour contract stay as they are. But in terms of preparation, there does need to be some at this point, because something is going to change here. So you need to review your contracts at the moment, and in particular consider whether or not there could be any benefits actually offering employment contracts now to those with fixed hours to your staff. Also, management training is going to be really important here on the updates as well, because we need to avoid being exposed to any risk. So next one, please, Dan. Fire and rehire. So, as we know, there were initial changes made by the Conservative government, which included the introduction of statutory code of practice. The key elements of this change by the Conservatives were clear guidelines for employers to provide detailed information about proposed changes. This included who would be affected, the business reasons, and the anticipated timings. So employers needed to engage in meaningful discussions with employees or trade unions to explore alternatives to dismissal and re-engagement. So more in-depth consultation was required. Employment tribunals were also given the authority to apply a 25% uplift compensation if it was found that an employer had unreasonably failed to comply with this new code. It was also clearly outlined that businesses were prohibited from using threats of dismissal to pressure employees into accepting new terms, less favourable terms. Labour's proposed changes to this recently changed code are more stringent. We're looking at stricter conditions where fire and rehire practices will only be allowed as part of a restructuring process, which is necessary to keep the business viable and preserve its workforce when there are no other alternatives. Labour plans to strengthen the new code, and that code came into force in July. The Labour government also aims to provide effective remedies for employees, requiring employers to have more than a substantial reason for changing terms. So overall, while the Conservative proposal focused on ensuring it was fair treatment and consultation, the Labour proposals aim to significantly restrict the use of fire and rehire practices, making it a real last resort with stricter conditions and enhanced protections for employees. So we'll watch this space on what comes through the Employment Rights Bill on this one. But in terms of preparation, you need to familiarise yourself with the code or speak to your HR teams. Your HR teams absolutely need to be familiarising themselves with the current code and when the new updated proposal is put in place. Probably a good idea to review your current structures as well, alternatives to dismissal, and certainly retrain your management in consultation and liaise again with your HR or your HR support, however your business works with your HR, to ensure procedurally everything is absolutely above board, because this is a really important one. The next one is the one that I think has got everybody talking. Probably the most shocking for employers was the announcement of their day one right to unfair dismissal. Key points of that being immediate protection. So employees will gain protection from unfair dismissal starting from day one, their first day of employment. This means no more of the assumption that it's lower risk to dismiss anybody under 2 years service. There will also be fair dismissal requirements. Employers must have fair and transparent reasons for terminating employment, ensuring that dismissals are justified and not arbitrary. Policies and procedures are going to have to be followed really, really thoroughly when this one does come into place. This measure aims to provide greater job security and stability for all workers, reducing the risk of unfair treatment. We've also got, in addition to the unfair dismissal, they've proposed parental leave will be a day one right rather than qualifying after 1 year. So that's the leave where employees have got the right to take 18 weeks unpaid time off for each child or adopted child up to their 18th birthday, which should be used to look after their welfare. And sick pay is another one. Labour is proposing strengthening this by removing that 3-day waiting period and also removing the lower earnings limit to ensure that all workers are able to receive it from day one. So this was announced in the King's Speech. The law's expected to be included in the Employment Rights Bill, which again, 12th of October, we will see what it says. But before being signed into the law, the bill would need to go through the Houses of Parliament. It could be amended along the way. This is going to take several months. Even after the bill does become law, many measures still won't take effect immediately because they may need significant secondary legislation or codes of practice or both to put them into practice. So our view remains at the moment that this significant change is not going to happen this year. The introduction of day one unfair dismissal rights is probably the biggest one, certainly the one that I think a lot of our clients are the most concerned about or interested in about how it's going to affect them. It's the biggest change on the horizon, but this is going to require an updated, possibly even new ACAS code of practice, which will need to be consulted on. So we think it's still quite unlikely that this change is going to be implemented until October next year, or even possibly the April of 2026. So in terms of preparation, which is on our next slide down, we do need to prepare. It's something that the Labour government is certainly pushing, and I think is going to be a real key focus for them. So start to revise employment contracts now, ensuring that they're clear, comprehensive, and outline expectations, job roles, and performance standards. This can be really, really important when it comes to somebody potentially not performing and not having that option of the under 2 years service to do that short service dismissal as easily as some may like to do. It would be a good idea now as well to review and implement robust onboarding processes and strengthen your onboarding programs to include thorough training, clear communication of job expectations, regular check-ins, address the issues early on. Another really important preparation, if you don't already have it, would be to develop a structured performance management process. These are all things that are going to be really, really important. They already are really, really important, but more so than ever if employees are now going to get day one rights. You also need to provide training for your managers on the implications of the new law and the best practices for managing dismissals fairly and, more than anything, legally. Review your policies and procedures. I think grievances, disciplinary processes, these are the ones that are going to be really needed to be focused on. And more transparency is going to be needed within your probationary periods. Review your probationary period process. If you don't have one, get one. It's something that we support a lot of our clients putting in place, as this is going to be a really important stage in the employee's life cycle when this all changes. I'm sure there'll be a lot of questions on this one. So our next one is flexible working, which I feel like we've only just discussed and we're going to discuss again. So Labour are proposing that flexible working is to become a default from day one for all workers. except where it is not reasonably feasible. This includes flex-time contracts and hours that better accommodate school term times, things like that. At the moment, everyone has got the right to request flexible working, but an employer can reject it, as you'll all know, on one of the 8 statutory grounds. And there's no real mechanism for scrutinising that rejection. We will have to wait to see what the fine detail of what is not feasible for an employer, and that might include potential further interrogation into how we reject flexible working requests. The law, again, is expected to be included within the Employment Rights Bill, to be introduced 12th of October. In terms of preparation, there may need to be a bit of a cultural change in some organisations to really embrace that day one flexible working right. And contracts are probably going to need a review as well. And policies, yet again, even though we've just done them, will need to be updated again. So we now have the protection for new mothers, which again, I feel like I've only just talked about, and we've only just updated all policies, but we're going to do it again because that's what we like to do. The law has only recently changed in this area so that pregnant employees and employees on maternity leave, as well as mothers that have returned to work within 18 months of their baby being born, must be offered suitable alternative employment in a redundancy situation. This new legislation, though, is going to go a lot further than this. Labour plans to make it illegal for an employee to dismiss a woman who has had a baby for a period of 6 months after their return from maternity leave, except in specific circumstances which have not yet been set out. So like feasibility in the previous slide, we now don't know what these specific circumstances are, but we will get some more of that information when we get to see the actual Employment Rights Bill. It's expected that this right would be applicable during maternity leave as well as upon return, but this is still yet to be confirmed. So in terms of preparation for this, as with the others, we need to keep up to date on these changes, and we'll have to update all of our policies in line with the changes when announced. We have to liaise with management, make sure that they're trained on the legislative changes as well. The next point in the Employment Rights Bill is the Fair Work Agency. So Labour also intends on establishing a single enforcement body known as a Fair Work Agency. And the idea is that this will strengthen the enforcement of workplace rights. The agency will have the power to prosecute and fine companies that breach employment laws, ensuring that employers who exploit their workers face significant consequences. The agency will also uphold a fair work standard to recognise employers who drive up employment standards. So this will be a standard that all employers can strive to achieve, which would also potentially include an assessment criteria, then certification and potentially public recognition as well for meeting those high standards. As announced in the King's Speech, this is expected to be included in the Employment Rights Bill, but there's not much more information on that at this point. And also we're looking at a fair pay agreement. If we just go back one, sorry, thank you. This is going to be introduced firstly to the adult social care sector. There are hopes that this proposal starts a dialogue regarding proper funding, in turn facilitating better pay for staff and assisting in retention. Retention is a big key thing for the Labour government. Labour's fair pay agreements are not limited to the social care sector. They are intended to cover multiple sectors, but the social care sector is a priority for the initial rollout at this point. Labour plans to start with the social care sector, then potentially expand to other sectors based on the outcomes and effectiveness of how this has worked for social care. The agreements aim to set minimum standards for pay and working conditions across various industries, ensuring fair treatment for workers in different sectors. And at the moment, and I'm not 100% sure if this has been confirmed, that's looking at about £12 per hour as the minimum for the social care sector salaries. This again was announced in the King's Speech. It's expected to be included in the Employment Rights Bill, and more information will follow on the 12th of October. Moving on to education. So the School Support Staff Negotiating Body, the SSSNB, this was abolished in 2010 by the Conservative Lib Dem coalition government. The decision was made by the then Education Secretary, Michael Gove, who argued that the SSSNB didn't align with the government's priorities for greater deregulation of pay conditions for the school workforce. So reinstating that body, the Labour government aims to establish national terms and conditions, career progression routes and fair pay rates for support staff. This move is intended to ensure that support staff such as teaching assistants and administrative personnel receive consistent and equitable treatment across the country. So this, they're also referred to in some schools as the professional services side, not just the teaching side. So how you can prepare for this, if you work in the education sector, is review your policies. They will absolutely need to be redrafted, and engage with the unions as well. Build relationships with them now so the communication channels are open, so everyone can understand the new framework when this does come into place. Consider training and development needs as well for the support staff so that they can achieve this career progression that they're planning to put into this new framework. So trade union changes. Labour's Voice at Work section of the plan centres around the idea of bringing in a new era of partnership. So they want to do this by, first of all, repealing the minimum service levels in relation to the industrial action as per the Minimum Strikes Act, which we covered in our last webinar, and I will touch on again in, I think it's the next slide. They are reversing the changes made under the Trade Union Act 2016. Unions are going to be allowed now to ballot members electronically in addition to ballots via post. And they're looking at simplifying the process of statutory recognition for trade unions and introduce a regulated route to ensure workers and union members have a reasonable right to access a union within workplaces. There will also be additional rights for trade unions to access workplaces to meet, represent and recruit, and also strengthen protections against unfair dismissal, threats and blackmailing. It is also introducing a new duty on employers to inform all new employees of their right to join a union on a regular basis, as well as putting this into contracts of employment. So again, 12th of October, we're looking at more details, and in terms of preparation, contracts and policies need to be reviewed, and given the move is intended to make it easier for workers to access unions and unions be recognised within the workplaces, additional support from your HR teams, HR consultancy, in-house is going to need to be, they're going to need to be involved a lot in these processes. So staying on this topic slightly, then I just mentioned that the repeal of the Minimum Service Levels Act. On the 6th of August, the government announced that the Minimum Service Levels Act 2023 will be repealed. I covered this in our last webinar. It came into force in July of this year. So let's change it again. It was originally introduced with the aim of preventing employees who did not have certain length of service from taking part in strike action to reduce the volume of staff taking part. Labour see this as unduly restricting the right to strike, which can have a negative impact on industrial relations, which can lead to then increased absence, employee turnover, which can be more costly and longer lasting than the actual strike action itself. So Labour aims to reset industrial relations so that they are based on better, more quality relations, fairer negotiations, and a real buzz term for them at the moment is good faith negotiations. In terms of preparation, organisations, you're going to need to review your collective voice arrangements now. Need to ensure that they are effective and assist with your approach to trade union recognition, what it looks like. It would also be good practice for employers to regularly undertake contingency planning exercises so that you can prepare for future strike action if, God forbid, that does happen. And whilst the legislation will remain in place until it's formally repealed, employers should be encouraged to seek alternative means for dispute resolution at the moment. This could include voluntary agreements rather than imposing the minimum service levels. Another interesting one is our genuine living wage. It's going to affect a lot of employers at the moment and businesses. So the creation of the national minimum wage was a real significant achievement for the last Labour government. However, this Labour government plans to go a lot further. They intend to ensure that the minimum wage becomes a real living wage that people can truly live on. So to achieve this, they will change the low pay commissions remits, and alongside median wages and economic conditions, the minimum wage will now reflect the cost of living for the very first time. Age bands for the 18 to 20-year-olds will be removed, ensuring that every adult worker benefits from the genuine living wage. HMRC as well will have the necessary powers to enforce the genuine living wage effectively, including penalties for any non-compliance. This one's slightly different, so I'm not just going to say the 12th of October again. These changes could be achieved relatively quickly outside of the Employment Rights Bill because now the change requires any actual primary legislation. Preparation, you need to review your existing pay structures as well as looking at your budgets and financial plannings. This could affect an awful lot of employers that do pay the minimum wage at the moment. And of course, your contracts, policies, they will all need updating to reflect any changes when they do come into place. Move on to slide 19. We've got the draft Equality, Race and Disability Bill. So Labour plan to draft a bill to extend the equal pay regime so that it covers race and disability, as well as sex. So they're going to look at introduce mandatory ethnicity and disability pay reporting for employers with at least 250 people. Labour suggested that by revealing these pay gaps, it's going to enable companies to constructively consider why they exist and how they can tackle them. So this was brought up in the King's Speech on the 17th of July, and he declared that the legislation on race equality would enshrine the right to equal pay in law, promising a draft Equality, Race and Disability Bill. The bill is described as a draft bill, so it looks to be less of a priority at the moment than the Employment Rights Bill and is likely to take a bit longer to become any kind of law. It's going to be challenging for employers to collect data for these reports, especially disability, as some employers, they may simply just not want to disclose that they do have a disability. So employers are going to need to look at their D&I strategies and their communication around gathering that data as well, so that if and when they do need to report that, they have appropriate data. The Pension Schemes Bill was also introduced during the King's Speech on July 17th. This bill aims to address several key issues in the UK pension landscape, including consolidation of small pension pots. So you'll have a lot of employees that have worked for multiple employers, and they may have a pension pot with several different providers that they've contributed a minute amount to, or and they tend to lose track of these. So this idea is to prevent people from losing track of their pension savings. Also, they want to look at a value for money framework, ensuring that all members are saving into pension schemes that deliver actual value. Also addresses requiring pension schemes to offer retirement products, so people have a pension, not just a savings pot when they retire. And the bill is currently in the legislative process. It will need to be passed through several stages in both the House of Commons and House of Lords before it can become the law. The exact timeline for it becoming law will depend on how quickly it progresses through these stages, but it is expected to take several months. So in terms of preparation, again, we need to provide clear and transparent communication about how employees' pensions will be impacted, provide regular updates and resources to help employees understand the changes, as well as ensure their pension schemes are aligned with the new framework and where competitive and beneficial for employees. When I look at implement financial wellness programs as well, that's a potential opportunity for you to empower employees with the knowledge and tools that they need to manage their pensions effectively. And it's also important to assist employees with the consolidation process and providing access to professional advice to help them navigate the changes smoothly. We are now moving on to the Skills England Bill. So the aim is to bring together the government, training providers, businesses and unions here. This bill hopes to deliver on their manifesto to commit to simplify and improve the skills system. The view being that they want to ensure the supply of skills needed for the economy and breaking down barriers to any opportunities. Once it's established, Skills England would hold responsibility for maintaining a list of accredited non-apprenticeship courses to ensure that they are of a high quality. And Skills England will bring together employers, unions, education and training providers and experts with national government to develop a single picture of national and local skills needs, identify the training for which the growth in skills levy will be accessible, and also ensure that the national and regional skills systems are meeting the skills needed and are aligned. Also, some slight changes to the apprenticeship levy. I can never say apprenticeship. No further details were provided in the King's Speech other than a statement that it would be reformed. However, in their manifesto, Labour have said that the reform would go hand in hand with the establishment of Skills England that we just talked about, and include the creation of a new growth in skills levy, with Skills England consulting on eligible courses to ensure qualifications offer value for money. So King Charles did confirm a reform on the apprentice levy in his speech. We're yet to hear any more information on that though at the moment. We're going to move on now to the changes that are imminent. They're coming in October. The first one being the changes to the tips and how we provide them to our employees, and then the Worker Protection Act 2023, specifically relating to harassment. So first of all, the tips, we did go into this one in quite a lot of detail in our last webinar, and I think we provided quite a few different articles and tools for our clients at HPC and policies as well, because there absolutely has to be a policy in place now, which I'll touch on in a second. But this is the new law that's governing how an employer must deal with customers' tips for its employees and workers. The legislation specifies that all tips, gratuities and service charges must be passed on to employees without any deductions. Employers who regularly receive tips are also obliged to have a written tipping policy. So tips must be paid to employees by the end of the month that follows the month in which the tips are paid by customers. And employers must fairly and transparently distribute the tips, but they can choose how that this is achieved. So, for example, they could choose to share the tips amongst those employees who have customer-facing contact. Timescale of this is 1st of October. So what's that? A week and a little bit. And if you haven't already done this for the 1st of October, there must be a policy in place if your business receives tips. You also need to ensure that your payroll is aware of any of the requirements and have your systems in place to make sure that these tips are divided fairly and that they're paid appropriately. So again, another one that we covered in our last webinar that is due to come into place in October. Employers are going to have a duty to take reasonable steps to prevent sexual harassment of their employees under this new legislation. The Equality and Human Rights Commission, the EHRC, will have the power to take enforcement and action against the employer. In addition, if an employment tribunal finds an employer failed to take reasonable steps to protect workers, it will be able to order them to pay the 25% uplift to any award of compensation for sexual harassment. So there's also, additional huge financial implications here for not meeting these requirements. In its plan to make work pay, it sets out plans to make the law more stringent by giving employers the duty to take all reasonable steps, and that's a real key phrase here, all reasonable steps, as well as setting out plans to require employers to prevent sexual harassment by third parties. So it's not just your staff, it's also customers, suppliers, contractors. Third parties are also relevant here. However, the EHRC has now completed a consultation about amending its technical guidance on preventing workplace sexual harassment. And this updated guidance does contain lots of reference to that third-party harassment. We do need to wait for the consultation's conclusions, but if the updated guidance is introduced, it would give the EHRC the power to enforce action. And if an employer fails to take those reasonable steps to prevent harassment by third parties, as well as internally with their own workforce. So 26th of October is the big date for this one. It will be an amendment in the Equality Act 2010. There are no details about the nature of Labour's proposed changes or when they will be introduced just yet, though. Preparation for this one is quite a big one. And again, if you haven't already, you need to really get this in place. So to be able to demonstrate that you've taken these reasonable steps, employers need to keep records, which are likely to include statements about not tolerating harassment of workers, and when an industry permits, refusing in future to deal with any customers, suppliers, contractors that act in breach of their rules. I would conduct a risk assessment as well, potentially to identify and address any potential risks in this area, where within the business, including review the past incidents you've had, if God forbid you've had any, assess if you've got cultural problems potentially, and evaluate the impact of any third-party interactions. How regular is it that your workforce comes into contact with third parties, and what is the risk there? You're going to need to ensure that your existing policies on sexual harassment are comprehensive and up to date, along with establishing clear and confidential reporting mechanisms for employees to report incidents of harassment. These need to be really, really thorough. It's also going to be necessary to implement training on the issue, making it clear to workers who have any complaints where they need to be brought to, what we do as a business to prevent this, how we support our workforce, and how we deal with any issues. That could be considered one of the reasonable steps to prevent any kind of harassment in this respect. So training is going to be a real big one, and an awareness for your workforce. And that's not just your management being trained as well, it's the rest of your staff on awareness. So we'll move on now to things that were covered in Labour's manifesto, but that weren't mentioned in the King's speech. These are additional items that were listed, but so we're going to look very briefly on these ones. So if we just move to our next slide, which is the paid carers leave. So they're reviewing at the moment the benefits of whether paid carers leave would benefit, I guess, carers. This was mentioned in the Labour's manifesto. However, it was absent from the Employment Rights Bill and the King's Speech. So we're not 100% sure yet what this looks like, what the proposal could be on this, but it is something that it was said to be on their radar in the manifesto. So we will have to wait to see over time if it comes up again. And if so, what impact that might have on businesses. Single worker status has been one that's been kind of talked about an awful lot as well. So as part of its plan to make work pay, Labour proposed the removal of the UK's three-tier system and creating a single status of worker in which people are either employed or self-employed. So no longer having worker, employee, self-employed, just simply worker or self-employed. Labour have said that they'll consult in detail on a simpler framework that differentiates between workers and the genuinely self-employed. And this proposal would remove qualifying periods for the basic rights and protections to give workers day one rights when starting a new role. There's no consultation had on this yet, and there was no reference to it in the King's Speech. So Labour have acknowledged that this will take some time. Therefore, we don't expect to see the change to come into place straight away on this one, but preparation should still be in the back of your mind, something to be considering. I'd conduct an audit on your workforce if you can do, to determine the number of people that you've got in these three categories, and understand how impactful the changes could be on your organisation if you do have multiple types of workers, employees, self-employed. You're also going to want to assess your financial impact here arising from the current workers gaining those additional rights and benefits, and what if any implications this could create for you. Another big one talked about, a hot topic at the moment, is the right to switch off. So Labour's pledged to introduce the right, which would give employees the choice not to engage with work correspondence, including emails, phone calls and instant messages whilst not working. I mean, we are all guilty of doing this outside of working hours, and for some people it's absolutely no problem, me being one of them. It's just a way of my life and how I work. But Labour has indicated that it's going to follow similar models to those that are already in place in Ireland and Belgium, allowing workers and employers to have constructive conversations and work together on bespoke workplace policies or contractual terms that benefit both parties. The new right will be enacted through a code of practice, another one for us, with an obligation on employers to enter into workplace agreements documenting clearly the contact hours and tailored right to switch off policies. So workers who are repeatedly contacted outside of normal working hours may be able to claim uplifted compensation in a successful tribunal claim. They wouldn't be able to go to make a claim solely based on this code of practice, the right to switch off, but they could add it on to another claim. A timescale for this, it didn't feature in the King's Speech, although it may still be contained within the Employment Rights Employment Rights Bill, which again is expected to be published in October. It is unlikely though that any legislation will come into place or into force before next year. Preparation for this though, I mean, in terms of the right to switch off, it should always be in an employer's mind anyway. It's the well-being of their workforce, isn't it? So you need to find the right balance between productivity and the need to agree clear boundaries and support well-being. It's not going to be a one-size-fits-all. There needs to be a balance, and that will depend on your business, the sector that you're in, the industry. Have clear policies though that are related to any new code if and when it does come in, where you'll want to clarify the circumstances where managers can and cannot contact their staff outside of their usual working hours. Management need to be clear on this as well. So training is going to be a real big one. There's going to be a bit of a cultural shift, I imagine, for quite a lot of businesses. So that's definitely something that you'll need to take into consideration. And you really need to be encouraging your workers to take their daily and weekly rest periods and rest breaks, and their annual leave entitlement as well. You'll need to monitor workloads, which I'm sure everybody does anyway, but these need to be allocated fairly. You want to avoid employees feeling overwhelmed, and then the potential here of working outside of their hours, being contacted outside of what their hours are. And maybe you could carry out surveys as well, encourage conversation with your employees as well, because there might be some workers that aren't prepared to disconnect and actually are quite comfortable with it. And obviously, you know, employee wellbeing training on mental health awareness and how to disconnect is a really important one as well. We've found, you know, remote working full time, people have found it difficult to shut off when their office is in their house. So these are all things that are really key to kind of explore if this is going to come into place. Employment tribunals, this is a real big one, and one certainly from our perspective at HPC, that there isn't enough information at the moment, and we really want the information. The Labour Party has proposed extending the time limits for bringing employment tribunal claims from 3 months to 6 months. So whilst this extension allows more time for resolving complaints through grievance procedures before filing a claim, it is also likely to result in an increase in tribunal claims. And as we know, they are already backlogged massively. So this is going to have a real impact if and when this extension comes into place. So in terms of preparation for this at the moment, we just need to be aware of these potential changes, consider how they might impact your processes, your resources, grievance processes. Again, we'll probably need a good review on this one. And your HR teams, any kind of employment law support you get, you need to keep on top of, making sure they're on top of this legislative change if and when it does happen. Menopause. I'm very conscious that we are actually coming up to 10 o'clock here. Vic, sorry, I've just realised. And I've still got about another 3 or 4 slides. Are we happy to go on? Yeah.
Sorry. Yeah, crack on, and then we'll at least can send the recording. If anyone needs to leave, we'll send it over to them.
Time has got away with Labour's manifesto and employment rights bill. It's never ended. Right, so just on menopause then, Labour plans to address the issue of people experiencing the menopause, struggling at work and not receiving the support necessary to manage symptoms. The government will publish guidance for this for companies of all sizes on uniform and things like uniform temperature issues, flexible working arrangements, logging menopause related leave and absence. The plan is to implement for businesses with more than 250 employees. Sorry, I can see things popping up in the chat and it's distracted me. It's proposed that employers with more than 250 employees will be required to produce a menopause action plan outlining how they will support their employees during menopause. So preparation, we need to normalise that conversation of menopause. I know that the next peopleHUB, Vic, we're actually, I think, is menopause related. So that's going to be a real good one to attend, everybody, if this is going to impact your workforce. Training policy is going to need to be updated, and of course consider all areas of support where available. The next one is terminal illness. So Labour has encouraged employers and trade unions to register for the Dying to Work Charter. This is a campaign for additional protections for terminally ill workers to ensure that those diagnosed are treated with respect and dignity and supported at work. The Dying to Work campaign, supported by various employers, aims to provide additional employment protection for terminally ill workers who need greater safeguards from employers who exploit the legal loopholes to dismiss them due to their illness. This campaign seeks to address this critical issue and ensure that workers facing terminal illnesses are treated with compassion and dignity in the workplace. We have another one on redundancy rights, where in Labour's plan to make work play, we've got Labour states that simply it's going to strengthen redundancy rights and protections for employers. For example, ensuring the right to redundancy consultation is determined by the number of people impacted across the business rather than in one workplace. The trigger for collective consultation will likely become broader than it is currently as well. And should the government implement its plans, employers will need to track all redundancies across various workplace locations rather than the current one establishment rule. So that's a big change there. In terms of timescale, it was mentioned in the manifesto. However, it looks to be absent from the Employment Rights Bill and King's Speech. So we'll just watch the space on this one. And in terms of preparation, we'll need to review our redundancy and consultation processes. Last slide, everyone, and then I'll stop talking you to death with employment law. TUPE, everybody's favourite topic. In July, the TUPE rules changed to allow employers to consult directly with employees if the business has fewer than 50 employees or if they're transferring fewer than 10 employees. So this has removed collective consultation from a lot of TUPE processes and made the processes simpler. Labour could undo this change, which would mean that businesses would have to go back to consulting collectively with employee reps for most TUPE situations. While Labour has said it will strengthen the existing set of rights and protections for workers subject to TUPE processes, it hasn't offered any more detail just yet. It was also not mentioned in the King's speech, so as it stands, there's a waiting game on this one. So in conclusion, the change in the government alone is keeping HR in a job for the foreseeable. Just constant updates on the horizon. It feels quite overwhelming on the face of it, but this is why our clients use us for their updates, policy changes, training. We're able to at least take on some of the burden off them for that. So once the Employment Rights Bill is published, we will send out a summary, and we will do absolutely everything we can do to support our clients. So if you need anything, please do get in touch. And thank you for listening to me go on and on and on.
That was fantastic. Thank you so much, Kendal. That was really, really informative. I know that a lot of people have said, I've put great comments, there's questions. There are questions here. What I'm going to suggest, given the time, is that if you're okay, Kendal, we can forward them to you, and if you could answer them at some point, that'd be brilliant. And what we will do is forward on any answers to this, and also the recording. I think the recording is going to be key for this, for people to be able to watch again, just to remind them of what you've gone through today, but also to share to their colleagues in their organisations or to managers. There's so many considerations for all businesses. But yeah, thank you very much. And yeah, we'll wait to hear on the 12th of October from you, Kendal, of what's going to happen next.
I don't think I'm going to need 6 hours, not 45 minutes for that.
Yeah, we'll do it in sessions. It'll just be the whole of next year's sessions. So our next peopleHUB event, as Kendal did mention, is we have got Sharon MacArthur with us, who is AKA Miss Menopause. She is a celebrity in this space, raising awareness across the country, across the world, which is fantastic. If you have attended her event last time, please, I would encourage you to attend this one as well. It will be very different. She has told us different content, and I would challenge everyone as well to try and bring along one of their colleagues, potentially a male colleague, or your husband, or your partner, or your brother, anyone that you can, so that we can actually get a really good distribution of men and women at this event, because it's not just for women to attend, as we all know. So if we'll send out the details, love anyone to join that session, and also you are more than welcome to join our peopleHUB community. So again, we will share that information if you're not a part of that now. But I will let you all go to your day. Have a fantastic day, and thank you again so much, Kendal, for the session. It was really fantastic.
My pleasure. Thanks, Vic.